The Supreme Court hands down judgment this morning in the case of the Crown on the application of Ms. Robinson, Appellant, and the Secretary of State for the Home Department, Respondent. This is a brief summary of the Court's reasoning. The appeal raises a question of law as to the circumstances in which a national of a non-EU member state may be deported from the territory of the EU. Ms. Robinson is a Jamaican national who first entered the United Kingdom in 2002. Initially, she was granted leave to enter for a limited period, but following her marriage in 2003, she was granted indefinite leave to remain. On the 5th of October 2006, the appellant was convicted of the serious criminal offence of supplying a Class A drug, cocaine. She was sentenced to imprisonment for 2.5 years. On the 20th of November 2007, the Secretary of State signed a deportation order in respect of the appellant. After that order was signed, the appellant began a series of legal challenges to her deportation. In 2008, while still in the United Kingdom, the appellant gave birth to her son, whom I will call D. D is a British national and a citizen of the European Union. He is dependent on the appellant, so that if she were to be deported to Jamaica, D would be compelled to accompany his mother and to leave the territory of the EU. Article 20 of the Treaty on the Functioning of the European Union provides that European citizens shall have the right to move and reside freely within the territory of the member states. The Court of Justice of the European Union, the CJEU, in the case of Zambrano, relying on Article 20 of the treaty, held that a parent who was a national of a non-EU member state was entitled to a right of residence if the parent's expulsion would require a child who was an EU citizen to leave the territory of the Union. This right of residence for the national of a non-EU member state parent was expressed in unqualified terms in Zambrano, so as to be thought to prevent expulsion of the parent in all circumstances, even if that parent had committed serious criminal offences. Ms. Robinson relied on what has become known as the Zambrano right of residence before the Upper Tribunal, which held that the right of residence was unqualified, so that her protection from deportation was absolute. The Secretary of State appealed to the Court of Appeal. Before the appeal was heard, the CJEU delivered judgment in 2 cases, which restricted the extent of the Zambrano principle. In one of those cases, it held that the right of residence was not absolute, so that in exceptional circumstances, a member state may adopt an expulsion measure. On the basis that the right of residence was not absolute, the Court of Appeal allowed the Secretary of State's appeal and remitted the case to the Upper Tribunal for redetermination. In doing so, the Court of Appeal held that the phrase exceptional circumstances was not an additional requirement which the state must satisfy, but merely summarized the exception to the general rule that D, a person who enjoys the fundamental rights of an EU citizen, cannot be compelled to leave the territory of the EU. Ms. Robinson appeals to the Supreme Court, contending that the phrase exceptional circumstances created an additional hurdle to deportation, so that she had enhanced protection against deportation. The Supreme Court unanimously dismisses the appeal for the reasons set out in a judgment given by myself, with which the other justices agree. The reasons for this can be summarized as follows. The Grand Chamber of the CJEU has now considered the restrictions on the Zambrano principle in 3 cases. In one of those cases, Advocate General Spuzner proposed that the restriction to the Zambrano principle should be confined to exceptional circumstances and require an imperative reason relating to public security. The CJEU did not adopt the proposal in relation to an imperative reason relating to public security. Furthermore, a textual analysis of the judgment in that case demonstrates that the CJEU used the phrase exceptional circumstances in the sense that an exception could be made to the general rule that a Zambrano carer could not be compelled to leave the territory of the Union. It was not stating that certain undefined exceptional circumstances had first to be demonstrated. A consideration of the other two cases supports the conclusion that the CJEU has never stated that there is an additional hurdle, that there must be exceptional circumstances. Ms. Robinson's appeal must therefore be dismissed.